Good morning all. We're here for a hearing on matter CFI 37-2017 before the Deputy Chief Justice, Sir David Steele. The claimant is represented by Galadari Advocates. Lead counsel is Harris Bohr. The defendant is represented by KBH Kaanuun. Lead counsel is Bushra Ahmed. Assisting is Patrick Dillon Malone.
Good morning. Yes.
Good morning, Mike.
Good morning.
We've agreed to divide time up like this. I'll be going first on behalf of the claimant in relation to the application that's before you, the inter partes application. And then my learned friends will reply and then respond, and I'll reply after that. We each envisage only taking 2 hours each.
So you're giving yourself 2 hours each, you said?
Yes.
Yeah.
So we may be able to complete everything today.
Right.
Fair win.
Okay.
So with that, I mean, this is an adjourned hearing, as you'll recall.
Sorry, before you start. One housekeeping matter, my lord. We produced 2 documents Thursday last week to the other side. I don't think there's any objection being taken to those documents. And if there is, I haven't heard that objection. But may I have those up to the bench, my lord?
Okay.
No objection? No. Please. My lord, I think the appropriate place to insert those is at the back of Soman Nair's witness statement or exhibit.
Somebody put a hole in it, that would help. Thank you. So which bundle do we want?
Bundle 1. So tab 20. You'll find Mr. Nair's witness statement, and right at the back of that bundle.
Hang on, divided which?
20.
But that's not bundle 1.
Bundle 2, my apologies. And my lord, right at the back is probably the safest place to put it.
Okay.
And I can give you the number in as soon as we have an adjournment, if that helps.
So what order do they go in?
So, right at the end, the last page in that bundle is 832.
Yes.
So, presumably, let's put them in date order. So the first document would be the 8th of September 2016 document.
Yeah.
And that starts 833.
Yeah. Well, I wouldn't have thought that was a good idea, because that's bundle 3.
I think we can slip them into, of course, 832A, sorry, my apologies. So the last page of that document should be 832G. And then the second document.
Sorry, I haven't caught up yet. Hang on a minute. Yeah.
And then the second document dated the 27th of September with the rag foodstuff headed paper 832.
Yeah. Okay.
Thank you.
Thank you.
For the record, we don't object to these. These documents were presented to us on the evening of Thursday. We haven't had a chance to take any detailed instructions, but we don't object to that. So we do put that down for the record. The probably best place to start is to look at our amended application notice, which is at tab 17 of bundle 2. And you'll see that there's essentially 2 aspects to our application. And the second one is is asked for in the alternative. So the first aspect we call the share transfer element, which is essentially for our client to regain control over the company of which he agreed to purchase and the sellers agreed to sell. And there are three aspects of this. One aspect is simply make an order transferring the shares. But we've also put in here an order for the claimant to be reinstated as a manager to the company. Because as we'll see, and I'll take you through the SPA in a moment, that it was a requirement of the SPA prior to any completion. In addition to that, my claimant or his nominee was entitled to be made a signatory to all of the company's bank accounts.
Sorry, I misheard this. The second one is you got transfer to the claimant of the shares. What was the second one?
So and reinstatement of the claimant as manager. You can see that in
Reinstatement of what?
the claimant as manager.
Manager, right.
You can see that in the typed, and then you can say it's in the amendment and/or reinstatement of the claimant or his nominee as signatory to the third defendant's bank accounts.
Yeah.
And again, that is a contractual requirement, as we'll see. So that's the way we put that aspect.
Yeah.
The alternative to reinstating our client or moving the shares to him is to appoint a receiver over the assets of the company. And we put that in the alternative, and that's the way we've presented it in the skeleton argument, which you have. And so that's the focus for today. Now, in terms of the share transfer, clearly that can be done as an interim remedy, pending the final decision of the court in relation to that. But actually also under the RDC 2415,
Yes, 2415.
2415, if a remedy sought by a claimant in his claim form includes a claim for specific performance of an agreement, whether or not in writing, for the sale, purchase, exchange, mortgage or charge of any property, the claimant may apply under Part 24 for judgment. And we've referred to that in the amended claim as well.
So this is immediate judgment.
Yes. So, I mean, that's
on the basis that there's no arguable defence.
in relation to rescission and the acceptance of or repudiation of the agreement.
Well, I'm slightly lost. This application here is not for immediate judgment, as I understand it.
Well, it does refer to RDC 24.
Well, it may do, but as I understand it, the thrust of the application, as originally advanced and as perhaps amended, is for interlocutory relief in the form of a mandatory injunction.
Yes.
Right. Not immediate judgment.
Indeed. That is the thrust of it. And I'm simply pointing out, if the court does decide that actually there's no...
But it makes quite a lot of difference.
Yes.
Because the interlocutory judgment is not a final order.
No.
You're not seeking a final order, as I understand it.
Well, we had done, but we recognise today we will not seek that.
Right.
We will only seek it on an interim basis, which is of course a different test, as you say.
Okay.
So the place to begin is as I mentioned, is the SPA, which one finds at page 105 of Bundle 1.
Yes, thank you.
And I'm going to take you just to the main clauses.
Sorry, I picked up the wrong bundle. Divider.
It's divider 8, and it's page 105.
Okay. Thank you. Yeah.
So if one looks at clause 1.1, and just reads this clause. I'll try and resist the temptation to read these very long clauses out. one can just see reference there to a share purchase and an asset purchase. So so there's an agreement to purchase from the sellers the shares and assets of the company, including but not limited to all tangible assets. And then there's reference there to Annex 2, which are the premises. Automobiles, including vehicles, are detailed in Annex 3. And all intangible assets of the company, so not just trademarks, but all intangible assets of the company, such as goodwill, all intellectual property rights, including trademarks, are detailed in Annex 4, owned by the company. And then the premises, vehicles, and trademarks are referred to as assets. So that's what's being sold. At 1.2, the third line down, one can see that there's an agreement for the assets of the company to be transferred to the purchaser, free from any lien, charges, mortgages, or commercial mortgages. Clause 2.1 details the consideration to be paid. And you can see there's 3 payments of 1 million dirhams each. There's a 4th payment upon completion of satisfactory due diligence by the purchaser. And we say, therefore, what that implies, and we'll see this again later, is that the due diligence has to be satisfactory to the purchaser, not to the seller.
Well, are you saying that due diligence was satisfactorily completed?
Yes.
Right. So you paid the 2 million?
We did not pay the 2 million.
Why not?
Because what transpired was that actually there were other liabilities which the claimant...
Maybe so, and no doubt those need to be deducted from payment number 5.
Yes.
So why not pay the 2 million?
Yes. It wasn't paid. And
Why
I don't know the answer to
You
that.
don't know the answer?
No.
Right. Okay. I mean, that's the way it works, isn't it?
That's
You have
yes.
due diligence. If the purchaser isn't satisfied, then there is a system for dismantling the agreement. If he is satisfied, he has to pay another 2 million.
Yes.
And then, theoretically, there's outstanding a further 5.5 payable over 6 equal monthly instalments, but that is subject to deduction in respect of various matters.
That's correct.
That's the way it works.
That's correct. That's what the agreement says. We can't get away from that.
No.
What happens is...
But there's nothing in the agreement which says that the deduction... Well, there's nothing in the agreement which says you can postpone payment of the 2 million, but equally there's nothing in the agreement which says that the purchaser's assessment of the deduction from payment 5 is binding on the seller.
No. The seller...
The purchaser can't come along and simply say, well, I'm advised that the deduction from payment 5 is X, therefore I'm going to deduct X.
Correct.
Right. But that's what he's done, isn't it?
No, my lord, it's not what he's done. What we'll see is that what in fact happened, and this may be an explanation as to why the 2 million wasn't paid, that a auditor firm called Thoruvil was appointed as a due diligence auditor.
Well, I'll have to look at that perhaps, but I've heard about that,
Yes.
and he came to the conclusion that there was a very significant... Sorry, that's not right. He came to the conclusion that there were certain figures which represented the asset position of the company.
That's right, and that only 91,000 dirhams was payable, and that's taking into account all the remaining.
Well, that may be right, but that's not binding on the seller, is it?
It's not binding on the seller,
No.
and in fact, and I think this is quite important for us to state this outright, that what the claimant does, the seller comes back and says, we don't like this report. The buyer then says, okay, you can retain Paul and Hassan, who are the auditors of the company, and they can do a review to see that credible matters.
Well, he doesn't have to give him permission. It's just a question of how they're going to resolve the dispute.
Yeah, that's right. That's right. And Paul and Hassan produce this report.
Right.
The buyer has a number of issues with that, which is set out in his first statement.
May well be so. Yeah.
That's right. And he calls for the seller to sit down and discuss these discrepancies and differences,
Right.
try and reach a figure. And this is where the claimant says it all goes wrong, because actually the seller then resists actually sitting down and discussing what the correct figure should be in relation to the Crowe-Horwath report and the Paul and Hassan report, and to discuss what the differences are.
Well, if there's a dispute, the parties can seek the assistance of the Court of resolving it.
Well, that's what we're doing here.
Well, he may be doing it now, but
yes.
at the time when the dispute arose, that was the way of dealing with it, wasn't it?
That was, and what the claimant, there were other things going on, of course, because the claimant was appointed as the manager to the company.
Right.
And he was facing issues in relation to that because he wasn't having checks signed for suppliers who were then demanding payment. And remember, from the 31st of December 2015, under the agreement, as we'll see, the profits and liabilities of the company was the claimant's. So the way this agreement works is, as soon as these first three payments are made, or even before, in fact, he's appointed as a manager to singly manage the company. His nominee is appointed to the bank account, and he's there in the company, running the company.
Right.
If everything goes to plan, then he will take over the company, and everything from that point will be his, including the liabilities. And what he was facing was that there were suppliers to the company who were demanding payment, but he was not, his nominee was not entitled to sign the checks on his own. He needed the cooperation of the first two defendants. Right. And what he was saying is, and what he says in this case, is that he wasn't being given that. Actually, they were withholding their cooperation, and the company was suffering. In the meantime, he was personally putting money into this company to deal with these issues and demanding completion. And when I say demanding completion...
So what do you mean by completion?
Completion is to the finalisation of the amounts that were due.
Yeah, but until you've resolved the dispute
yes.
in regard to payment 5, there's no way of completing, is there?
Well, there's no way of completing if one takes the agreement that one needs to pay consideration, which is a reasonable construction of this agreement. In other words, that one needs to pay the consideration to complete. But his position is he was being prevented from completing, and that's why he has come to this.
Well, as I understood his position, he was saying he was prevented from completing because there wasn't agreement about his 91,000.
No, what his position is, actually, I paid everything, because if one takes the Crowe-Horwath report, and also then what transpires after the 31st of December, because there were other liabilities which were being incurred, which was for the account of the seller, then in fact he says, I've actually paid all the consideration.
Well, it's not being, that's it. You say that the balance of account between the parties yes. may have resulted in some further sums being due yes. or not. But so far as the provisions of Article 2 of the agreement is concerned, matters were never completed, were they? You never paid the 2 million, and you never resolved the dispute about the 5.5. Or have I misunderstood something?
Well, I'm being told that he paid the 2 million, but I need to get clarification on that.
Well, I think you need to actually perhaps adduce a bit of evidence about that, because that comes out of a clear blue sky.
Yes.
If I may say so.
The issue may be that the way that payments were made is payments were being made into a company account, which was being handled by the sellers. And what the sellers say is that that's not payment of consideration. But actually, what the parties had agreed between them is that there were two accounts, and the sellers were holding monies in one account, and that was their monies. Right. And the buyer was controlling the other account, and that was his monies within
the that's a treat to look forward to, no doubt.
Yes.
But can I just, forgive me for going back to basics a bit here. Mm-hmm. You're seeking a mandatory injunction, effectively.
Yes.
And it follows, does it not, that it's not sufficient simply to demonstrate some kind of arguable case. You've got to show on the material available before the court now that you have much the better of the argument.
Yes.
It's not an American sign-in matter. It's, I can't remember the names of all the cases now, but it's well established that as a matter of English law, that a mandatory injunction will only be accorded in circumstances where it's manifest that the potential for prejudice to one side very substantially outweighs the other, i.e. that the person making the claim must establish that he has or she has much the better of the argument. Am I right?
Yes,
yes,
that's correct. And we say we can do that.
You can do that.
Yes. But
well, I don't think you,
yes.
I haven't seen anything in your skeleton or indeed in the material which really seeks to grasp the burden that's on you. Indeed, I've seen no reference to any of these authorities.
Well, we approached it on the American sign-in basis. Because the claimant's position is actually he has number one, he says he's paid the amounts that are due. Number two, because under the agreement he is entitled to run the company prior to completion. He is entitled to be running that company prior to the amounts being paid, and we will see that. And he's not.
Just let me see that point.
So this is if one looks at 2.5.
Sorry.
2.5. 2.5. Clause 2.5.
Yeah.
So any other payments, if required, to be paid towards any penalty, fines, interest, unpaid dues, employees' gratuity, whatever incurred by the sellers until 31st December 2015. Or required for any transfers between this agreement, including but not limited to the shares and assets, shall be deducted from the purchase price.
Right, well that's the repeating something that's
correct.
Already
should be duly adjusted against payment 5. Right. The parties also agree that upon execution of this arrangement, the purchaser shall be entitled to nominate his representative to singly manage the affairs of the company till such time the transfer of the shares is not effected due to the unsatisfactory due diligence or the shares are duly transferred. And so point number one, from execution, he was meant to be running the company. And in fact, he was appointed as manager to the company. But what he says, he was excluded on or around the 9th of May. He says it wrongly excluded. The defendants say, well, he was excluded because he was overstepping his boundaries. But we say that's wrong, that's not correct, and actually he should be running this company. And so in terms of the American Sanamid point, we're saying that he is, regardless of whether or not completion has taken place or can take place, he should be running the company. That's the way this contract works. And furthermore, 2.7 is a reference to the account point that I mentioned earlier. So from the date of signing this agreement onwards, all bank accounts of the company...
Sorry, where are you reading now?
2.7, clause 2.7.
Yeah.
From the date of signing this agreement onwards, all bank accounts of company, including the bank accounts maintained with Commercial Bank of Dubai, etc., shall be operated with additional signatory nominated by the purchaser, i.e. Mr. Sajid Abdul Gaffar Saboowala, or any other person deemed appropriate by the purchaser. And then the seller shall immediately instruct CBD and HBZ.
Right, well, he's a joint signatory, I thought of that.
Yes.
Yeah.
So that's why at the beginning I took it to the application notice, because yes, we're asking for transfer of the shares, but actually, more importantly, he wants to be running this company, because if one looks at this agreement, one sees that in terms of the actual payments and liabilities and benefits, he is to get all the benefits from the 31st of December 2015, and he is responsible for the company, the liabilities for the company from that date. That's the cut-off date, and that's the date that the Pro-Wath report valued the company at. So really just to sum up how the agreement was meant to work, execution takes place, then the claimant starts to run the company. He has his nominee as a signatory to the bank accounts. there's a cut-off date of the 31st of December 2015, and after that date, he takes the liabilities and benefits of the company. Prior to that date, the sellers have to deal with the liabilities of the company. He says that he strives to reach completion. He appropriately retains Thoruvil. They say, oh, well, you actually only owe 91,000. The other side disagree. He says, fine. There's a disagreement. They go and get the Paul Hassan report. He begs them to sit down and discuss this, and they don't. But in the meantime, the company is not being run appropriately. He's then excluded from the company, and he's now left, shut out of the company, with no shares and no dialogue. And that's why he's coming to this court. And what he wants in the interim, this court will need to decide whether or not the consideration has been paid, and if not, the amount of the consideration that's outstanding that needs to be paid. But in the meantime, what Mr. Saboowala wants is control of the company. And the reason why, and we'll see this, is because there is evidence within the Thoruvil report of sham transactions being accounted for.
Yeah, well, I think that's
these kind of things.
Maybe so.
Yes.
But, it doesn't matter, does it, whether there's sham transactions or not? That's a pure piece of prejudice. You're saying it doesn't matter whether he's entitled to run the company, even if he doesn't have the shares.
Yes.
Yeah. So the thrust of your argument is 2.5.
Yes. And 2.7. Because he
2.7 is...
Yes.
But it's 2.5. An add-on, isn't it? He can't sign a cheque by himself.
No. 2.5 is the crux.
But how's he going to run the company if the cheques are not signed by the others as well? It's an extraordinary arrangement that he runs the company, even if he doesn't have any interest in the equity and has no control over the bank accounts. And the shareholders might vote him out, I don't know.
Well, it is a strange arrangement, but the way
it's absolutely bananas, isn't it?
It is, which is why one interpretation that we put forward is that actual completion should take place after due diligence, regardless of whether the amounts have been paid, and then the accounting
that can't be right.
Can't take place. Well, it's a difficult
construction. The purchase price is prescribed.
Yes.
There's 5 payments. Yes. One of which is open to debate, and it is open to debate until that's finished. Then the purchase price can't be finished.
And the problem with the 5 payments is it doesn't envisage a situation where not even the payment number, the 2 million payment is due. 4. It doesn't envisage a situation where the liabilities are such that payment is eroded. In other words, when there's...
I agree, it's not provided for. It's not suggested that there might be a situation in which more than 5.5 million is owed.
Yes.
But in fact... That doesn't prevent the 2 million being due.
It doesn't, except it's a new situation which wasn't considered, and then the court would have to say, well, what did the parties really intend by this? Did they really intend for Mr. Saboowala to pay 2 million?
I'm not going to rewrite this agreement, that's for sure. Right?
What
it really boils down to is that despite the, if I may say so, the balmy shape of this agreement, you're entitled to run this company because you have management control furnished by 2.5, even if the purchase price has not been paid, even if there's been no satisfactory due diligence, even if the shares have not been transferred, even if you're not the sole signatory of the account. It's an impossible way of running a company, isn't it?
Well, in relation to the things you just said,
it's not the way I'd like to run a company, that's for sure.
Then it's not. But there's 2 things. One is what the claimant's saying is he doesn't want to pay anything less than the money that he ought to pay. He is prepared to pay money into court to protect the position of the defendants, the first 2 defendants.
Right.
That's number 1. Number 2 is in the list of...
Well, I assume that's what offering to pay into court. The difference between... I'm not sure what he's offering at the moment. 91,000, i.e. he's paid, he says 3 million. He's offering another 91,000, but he's prepared to put into court 7.5 million less the sum that the accountants think might reflect the drop in the asset value.
I think he's prepared to pay more than that. I think he's prepared to pay the amount that he's paid. If I need to take the straight, but this is
what, 7.5 million?
Yes, yes. Because, well, he says he's paid 4.25, and we'll show you why that is the case. And then there's a dispute about that, but we will show you why we're correct on that point.
Sorry, I didn't get your figure then.
4.25.
4.25. Now I was asking about 7.5.
Yes.
Where does he get the 4.25?
He paid 3 tranches of 1 million each. Those are the first 3
right,
payments.
that I understand.
He then says later on the sellers asked him to make 2 further payments, and that came to a further 1.25.
Well, I know there's an argument about that.
There is, but we say that the arguments of the
well,
sellers...
assuming there is an argument.
Yes.
Is he prepared to pay into court 7.5 million?
Yes.
Right, okay. I just want to understand what he's saying.
Yes. And in terms, just one correction in terms of the list of things that you said. I mean, what he says is due diligence has been satisfactorily completed. It's just a matter of working out what the actual amount that he has to pay in is, if anything. When I say pay in, I mean pay the sellers.
Okay.
So, shall I continue just taking you through this agreement and then taking you to some of the documents?
Right.
The other, so if one looks at 2.2, and this is another factor actually when one looks at the nature of this agreement, it's not just that he was running the company. Actually, as he makes the payments, he obtains assets of the company. So if you look at 2.2...
Okay, just help me. As I understand, it's common ground, although this agreement solemnly refers to 3 annexures, they aren't there.
Well, there's a dispute. They're not there, that's correct.
Right.
There's a dispute.
Well, presumably both sides have got them.
No.
Why not?
What our position is that, and there was a witness statement from Mr. Qureshi, who was a lawyer representing the claimant, said he saw these annexures, and he said, will you send us a copy? They were prepared by the first and second defendants of the company, because they know what the assets are. He saw them and said, will you send us a copy? They said yes, and they never received them. One sees requests from Pro Horwath for these annexures, they never came. What the defendants say is that these annexures were never prepared.
Right.
And actually, there's some suggestion, well, you should have prepared them. They have tried to
That's an extraordinarily sloppy way of conducting a deal. I don't quite know how the legal advisors have got themselves in this mess.
It's not. One can't get away from the fact that it's not an easy deal. Which is why, my lord, we recognise this. This is why as we put in the alternative, that if the court says, look, there are issues here, and there are issues about the way the defendants have run the company that have been pointed out that haven't been properly explained, this needs to be dealt with by a third-party receiver, which will be under the instruction of this court, and that receiver can then assist this court in providing information as to what, in fact, that company is worth and what has gone on. And we say that is a very very sensible way of dealing with matters. But clearly we have to convince you that that is a just thing to do. And we would be happy with that.
That's your alternative.
Yes, and we recognise some of the difficulties that you pointed out. And we say at the outset that we would be happy with the receiver being appointed over the company. But clearly we have to take you through the documents and make that case. But at any rate, what these defendants do accept is that the annexes ought to have reflected the premises, the trademarks, and the vehicles that were owned by the company at that point in time. And there have been attempts to reconstruct what those are. But the point for today is that, in addition to running the company, our client was entitled, or is entitled, to hold the assets. Now, some of them have been transferred. He has 2 trademarks of the company which were assigned to him. The vehicles were not, and there's a dispute about why that is and whether they should have been. And the premises, I don't believe, have been transferred either. But what this clause 2.2 certainly suggests is that the assets in the annexures ought to have been transferred. You can see there's the fourth line up. The parties further confirm that the purchaser is the legal owner of the assets of the company mentioned in the Annexes 2, 3 and 4. And the parties shall execute all such documents without any further consideration required for notifying the relevant authorities. Now, in relation to the vehicle...
Yeah, but that's not a suggestion he can't do it without paying them money. Is that what you're suggesting?
No, he had to pay the first 3 payments, so I didn't read to you the first part of Clause 2.2. So the company said has confirmed that they've received the payment 1 and 2, and now is now obliged and bound to transfer the ownership of all the vehicles, free from any encumbrances, etc. And there's no dispute that these 3 payments were made. So that's just another factor to complicate matters further. Then there's reference here at 2.3 to security checks. And this features in the defendant's defence quite heavily. There's one check for 2 million AED and another check for 1 million. And the first check is to secure the transfer of the shares, and the second check is to secure the successful transfer of the trading house.
Yeah.
Then 2.4 deals with the due diligence process.
Well, let's just understand the position. There was some transfer of trademarks.
Yes.
Are you saying that that's incomplete?
We believe there are applications, as well as registered trademarks, there are applications for trademarks, which
well, there may be applications, but you can only transfer something you've got.
Well, if you recall, and I took you through the definition of what the trademark annex is at 1.1, it includes all the goodwill and intellectual property of the company.
Right.
And so we say that
an application for a trademark is goodwill, is it?
Well, it's intellectual property. I mean, it's potential.
An application. Right. Okay.
I mean, that's the position. The problem is, without the annexes, we don't know whether everything's been transferred.
Well, you'd have thought if you were the purchaser, you might make sure you got hold of a copy of the document. Anyway, so you say that hasn't been completed.
We just don't know if it's been completed.
Or you don't know. So, but nonetheless, you paid the check into the bank.
Yes.
Because
those
is that just to put pressure on, or was that some genuine commercial move?
What the claimant says in his second statement is that after he was excluded from the company on the 9th of May, and I'll take you to the contemporary documents shortly, and he had put in a lot of money into this company to pay for suppliers, for example, who weren't being paid by the company because the defendants weren't signing the checks. And then he was thrown out of this company. He then cashed, or attempted to cash these checks.
Well, they've got nothing to do with these other matters at all.
Yes, they haven't. They haven't, on the face of it.
So what was he doing paying the check in then?
He was, what he says is, and this is the way he puts it, summarising, that he'd incurred personal liabilities, and he was desperate and was worried about.
It doesn't sound desperate if he's offering to pay $7.5 million in court.
Well, he's quite prepared to pay money to obtain something back for it, the shares in the company. What he doesn't
use the word desperate, which suggests to me you haven't got any money.
No. What he was desperate in the sense that he put in money that he felt he would not get back because
So he decided to use the check, knowing perhaps for what it might not be honoured, in order to put some criminal pressure on the defendants. Is that right?
There's no evidence that he believed.
Well, it's an inference I'm pretty ready to draw.
Right. Well.
Okay, well that's that.
I mean, in terms of the inference, I can't say anything else.
Now, on the $2 million, there's a dispute as to what it was in respect of, as I understand it.
Well,
they say it's the cars, and you say, as it says in the agreement, the shares.
That's right.
But again, the check was presented.
It was presented.
Yeah. But I mean, here is an agreement which accords this court jurisdiction to determine disputes arising under the agreement. So what was your client doing going to the Dubai courts?
What he says in his evidence is that he was advised to do this, and perhaps badly advised.
Is he waiving privilege of that advice?
Well, he refers to talking to police at the time that he was excluded from the company, and then mentioning going to the Dubai courts.
But why was he going to the Dubai courts? I mean, I think there is an express jurisdiction clause.
There is, and of course, as soon as...
If there's a dispute between the buyer and the seller, it's this court to determine the dispute. So what's your plan doing going to the Dubai court? Other than perhaps to take advantage of the presentation of the checks, what else was he seeking to do?
What he was seeking to do in the Dubai court was in essence what he's seeking to do in this court.
Why? So why was he going there?
As I say, I can only go on what the claimant.
Well, you decided to pay no attention to the jurisdiction clause.
Well, the claimant's not a lawyer. He may have been badly advised, and it was a wrong jurisdiction.
Presumably he can read English because he signed this agreement.
He can read English, but he's not a lawyer.
No, but you can see everything in the document says that the jurisdiction court to go to is the DIFC. Yeah.
I mean, I'm going to resist the danger of speculating or trying to give evidence myself. I mean, the one point that one could think is that the company being a UAE company, and if the defendants were subject to the jurisdiction of the UAE, the non-DIFC courts, then the claimant may have thought, or his advisors, that it was appropriate then for them to be made personally, to have an order against them to personally do something. Because some of these applications, one of them was for a receiver over the company.
I'm sorry.
One of the applications that was made was for a receiver to be placed over the company.
Right.
One of them was
I can see that there's some disputes as to whether I would have jurisdiction to appoint a liquidator.
Yes.
It's a UAE, well, it's a Dubai company, is it?
Yes.
I can't remember, yeah.
Yes, it's a Dubai company.
It's not formed in the DIFC.
No.
Well, I don't know the answer to that.
Well, we've put in a case, Derby and Weldon, where the Court of Appeal makes it clear that to appoint a receiver, at least under English law, one doesn't need assets in the jurisdiction. And they went further and said, because actually the lower court in that case suggested that you need evidence that it was a case where there was a Luxembourg company, evidence that the Luxembourg courts would honour the judgment of the English court. But actually the Court of Appeal said, well, actually that's not the case. You don't need a Bannerbath order. Actually, the English court has jurisdiction to appoint a receiver over assets of parties who are subject to the jurisdiction. And we say certainly in this case, where it's a Dubai company, the court has that power. But it may well be that the claimant, and I'm not a non-DIFC lawyer, made a grave error in the sense that there's an express jurisdiction clause in favour of DIFC jurisdiction. As soon as he turned to this court, then that was pointed out to him, and then he has taken action to put that right. But he does say that what he wasn't trying to do was somehow steal a march on the defendants or intimidate them. The fact is, they presented checks which weren't backed by cash, and they weren't complying with the agreement, and he was getting nowhere.
Yeah.
So, we're jumping around a little bit, but it's all very useful. But 2.4 is the due diligence process, which I don't think we need to look at too much. Say that the defendants, what they say about this clause is that if the due diligence process fails for whatever reason, then the whole thing unravels. Because it's clear, we say, that what the defendants want to do is keep this company. So they're looking for ways to get out of the transaction, and 2.4, they say, is one of those ways. And we say that can't be right. But what this clause does, when one reads it, is it gives a right to the purchaser to unravel the transaction if he's not...
see the suggestion the purchaser has some kind of option.
Well,
Where does it say that?
Well, one has to read it into the clause, but when it starts at the beginning, payment for is mentioned in the above schedule, shall be made upon completion of due diligence procedure duly started by the purchaser to his satisfaction.
Right, he's got to pay the 2 million as soon as due diligence starts. That's all it says.
Yeah, to his satisfaction. Well, it says completion, it's unclear. It says upon completion of due diligence procedure duly started by the purchaser. So it does have the word completion there. And then at the foot of the page...
Yeah, that's it. So upon completion.
Yeah.
And that seems to have happened anyway. Right?
Yes. And then so the last lines of the page, last 2 lines, in case the company seller is unable to fulfill the requirements of the purchaser and or the due diligence, is unsatisfactory, of non-cooperation or incorrect information or misrepresentation or concealment by the company sellers shall be bound to return the already received amount of 3 million within 7 days of first written demand of the purchaser. So it's the purchaser that makes the demand, and it's the wrongdoing, for want of a better word, of the company and sellers which create that trigger. And that's why...
Yes, just tell me that your client is saying, is he, that he's satisfied with the due diligence exercise. As I understand it, he complains that he hasn't got a proper note of the assets in the form of vehicles or trademarks and other matters, and that there's been non-cooperation with regard to the conduct of the company, and he even goes so far, I think, to say that he has evidence there's been dishonest behaviour. Why is he saying that due diligence is satisfactory?
What he's saying is, there's lots of holes with this due diligence, there's lots of problems, there may well be other liabilities, but I want this company, what I don't want to do is tear up the transaction and unravel the whole thing. And therefore I'm willing to go on what's being found, and I'm willing to make a payment on what's being found and discuss those findings and make a payment on that basis, despite the fact there are all these other issues. I'm willing to put that to the side in relation to the completion and pay what the auditors have found. And therefore, yes, he could have grounds because of all the issues to say, I don't like this, the way it's been done, I'm not satisfied, give me all my money back. But he's never said that. And in fact, there is actually agreement. The defendants, even in their skeleton arguments, say that no demand has ever been made under this clause. And that's correct. When one looks at the documents, throughout this process, the claimant has always said, I want to complete, let's sit down, let's complete now.
Well, it doesn't provide the buyers with an express option. It simply says that the sellers have to return the money, and if the money isn't returned within a period of demand for its return, then various consequences occur. That's what it says, isn't it?
But it has to be the written, well, 2 points. First of all, it has to be the written demand of the claimants. So we would say there is an option aspect. And the second point is, if one was to construe this clause in the way that the defendants suggest, they could simply misrepresent everything, not comply, make the claimant's life a misery, and then get out of the transaction.
Well, that may be right. You'd have thought that that seems to me perfectly sensible for the buyer to approach it on that basis.
Well,
if he's going to face a disruptive, dishonest seller, he would want to get out of it.
Well, no, we would say no, because what the claimant has focused on this company. He's seen it as a positive purchase. He's entered into a legally binding agreement with the sellers of this company, and it makes sense, we say, as a matter of commercial common sense, for him to be able to say, I don't like what you've done in terms of due diligence so much that I don't want to do this anymore, or for him to say, I'm not quite happy, but I'll go with it because I want the company. And we would suggest that it has to be construed in that way.
Okay.
2.5 we've looked at, 2.7 we've looked at. The only other clauses I draw your attention to are clause 5, which is indemnification provision, page 113.
Yeah.
There's additional documents clause 6, which is cooperation clause, which again, which is relevant to the extent that when the claimant is trying to complete, one would say they would have to comply or cooperate at least. And then clause 7 is entire agreement clause, which is relevant to whether there are any other prior agreements or not.
What happened with regard to the mediation provision?
So the mediation, my client says, and there's evidence to this effect, that he attempted to have the other side agree to a mediator.
I'm sorry, say that again?
My client says that he wrote to the other side, requested the appointment of a mediator, but actually the other side wasn't cooperative. The other side said, well, we were cooperative, but, and they give some reasons why not. It would seem that the parties are agreed that they weren't able to reach agreement as to the mediator or the mediation process. And that being the case, then there's no issue of the DIFC court having jurisdiction.
Actually, I think I said to you that there was a DIFC jurisdiction clause. There isn't, is there?
What it says after, it says, failing the mediation, such dispute shall be finally...
Oh, yes, I'm so sorry, you're quite right.
Exclusive jurisdiction.
Thank you.
So that's the agreement. As I said, after execution, the claimant was appointed. His brother Sajid was appointed to the account as a signatory to the accounts. There was a assignment of trademarks, but as far as I can tell, nothing else.
Right.
And then one encounters these problems. So I'm going to take you through a series of emails, and you must stop me if you think...
Do you have a chronology?
There isn't one, and it would...
Well, that is very unfortunate.
Yes.
Makes life very difficult for me.
My Lord, we did prepare a draft chronology for our purposes, although it wasn't circulated to the other side, and I didn't want any criticism that I've prepared it late in the day, but I can offer that if that would assist, obviously.
Well, I understand it's not being seen or agreed, but no. I'm happy to receive it today, unless there's some objection.
No, there isn't, and it may well be helpful, so we're grateful for that.
Thank you very much, Ms. Hunter.
I've marked this copy. This is marked. Sorry, Mr.
Thank
and
you.
it does say draft. The only thing I would say, and I'll hand it up first and you can have a look at it, there is one date omitted from this draft chronology, or event even, and that is the notice that the defendants served on the 9th of July 2017. So that's why I've
right at the bottom of page 3.
I've marked my copy. Well, no, that's defendant attends public prosecution and pays 3 million. So the defendant pays 3 million into court because there's a criminal action pursued against them by the claimant. And then we've got the 9th of July on page 4, claimant proceeds to...
Yes, I know that.
Yeah, and then there should be a further insertion there. 9th of July 2017. The defendants serve notice to terminate the SPA.
Well, on the basis of accepting a purported repudiatory breach rather than some termination provision.
Yes, accepting repudiatory breach, yes, and relying on Article 86 of the contract law.
Thank you. Thank you very much.
Thank you.
And what I'll try, I mean, I haven't had a chance to look at this, but what I'll try and do is present you with the emails that go between the parties in chronological order, which may assist together with this table, which we haven't yet looked at. But if one turns to bundle 2, page 369,
You say 469?
369. 3. It's a tab.
Bundle 2 starts at page 425.
So it's bundle 1. I apologise. I've got slightly different. So here we have an email, 11th of August 2016, with a claimant writing to the first defendant.
Sorry, 269.
369.
Do you say 269 or 369?
369. 3.
Yeah, I got it,
So we'd like to bring to your kind knowledge the inconveniences to creditors caused by not signing the checks. Checks are kept on hold for your signature for the past 1 week. Creditors are impatient, irritated. Interruption in the routine operations by delaying payments to suppliers and other OS bills may spoil the reputation, trust, credibility.
So, I have no idea. What's this all about?
So this is the point that I mentioned before. The claimant is now in situ as a manager of the company.
Right.
There are suppliers to the company who need to be paid. And what the claimant is doing is presenting checks to the defendants, first 2 defendants, saying, can we sign these checks? I need to keep this company going. And what they're doing
they haven't been signing the checks for the joint signature.
That's right. And so they're not cooperating. This is August, and this is a theme that you'll see come throughout the whole thing. So this is August. In September, the Kuniyath report is then produced. And if you look at page 201 of the same bundle.
301.
201. 201.
Everything is as usual in reverse chronological order. Page 201.
Yes, there's a table.
A table from Crow-Haworth.
That's right. And this was submitted along with the report. And this is where the figure of 91,000 comes from. You can see that.
Yes.
Balance yet to be paid. And then behind that, and it starts from page 204.
So the date of this document is?
It was presented to on the 1st of September or thereabouts to the claimant, and then sent, I think, on the 3rd or 4th of September to the first 2 defendants.
Okay, thank you. Now on to 20.
So the actual report in a form of a presentation starts at 204.
Yeah.
And if one looks at 219. One sees references.
This is the executive summary.
Yes, and it starts sales. And then in the first bullet point of 1A, in 2014 there was dummy sales recording amount to AED 5 million, dummy closing inventory amounted to AED 2 million. This dummy sales of AED 5 million was recorded through MBT trading account, which we believe is a company or a trading account of the first 2 defendants. And AED 2 million was recorded under stock items. And then in the third bullet point, on the whole, it may be concluded that the profit of AED 3.6 million, as shown in the audited financials in 2004, was overbooked by AED 7 million. And at B, you can see some further reference. If you look at the second bullet point of point B on this page, there's reference to AED 5 million dummy sale recorded. There's a sale referred to as point A above. Then the next bullet point down, in 2013, according to Mr. Dinil Kumar, most of the sales...
Well, I'm not sure I read all this.
Yep.
The point being what?
Well,
as a result of due diligence, the buyer was advised that the accounts reflected a significant degree of what were called dummy sales.
That's right.
Yeah. Being what? Non-existent sales.
I believe so, yeah.
Bogus sales.
Bogus sales. Or sham transactions.
Right, okay.
And there's reference to that is going to be third bullet point.
Well, there we are, yes.
And then 228.
228.
There's just further references to this. So if we look, there's a heading branches and divisions. So the third bullet point down, further as mentioned earlier, MBT trading is the account used to record dummy sales. According to Mr. Kumar, such transactions are easy to identify and eliminate from the book, so that it is maintained separately under separate accounts. Then B starts, there may be other transactions arrangements like done with Ayush General Trading and MBT Trading, which may be recorded in sales and purchase accounts, distorting actual profit margins and affecting outstanding real balances of trade receivables and trade payables. 236 gives an indication of the problems that Crow-Haworth were facing in terms of cooperation in relation to due diligence.
236, yes. So this is a series of open items on the due diligence exercise.
That's right. Which they say that's just a summary of all the pending information. Then
So go ahead, yeah.
245.
Yeah.
The footnote at the foot of the page refers again to the 5 million variance. Then 248 at the footnote, the last footnote, is again a reference to the ISGT and MBT trading.
Right.
Then 279, page 279. There's reference to finding observations. So closing inventory as per books is AD 5.3. However, in the aging report, only 3.3 million was appearing. The difference of AD 2 million is a fictitious inventory entry carried forward from the year 2014. 284. There's reference now to the accounts of AIS Trade, General Trading, NBT Trading, and Majid Kutara Transport. On AIS General Trading, there's reference to recording fictitious purchase. I'm on page 284. And then MBT Trading, unsupported sales in order to maintain its level and meet bank requirements for availing loans. There's reference there.
So that's still on 284, is it?
Yes, that's on. It's
I see, yeah.
MBT Trading.
Right.
And then 297.
Yeah.
And you see a reference to there's a right-hand column with finding observations. So the last 2 points there. Only few confirmations were received, and of that, 2 had major unrecorded claims. This is now to do with suppliers. Hence, we cannot vouch for the accuracy and completeness of liabilities of RAG. There may be some more ongoing disputes with suppliers and unrecorded liabilities which cannot be commented on at this stage. Hence, it's strongly recommended to publish a public notice by which all unrecorded disputed claims may come to light. And 298 continues with that theme. One looks at findings, observations. From out of the total 50 creditors that RAG has, only a total of 6 creditors have confirmed their balance. So, in other words, there may be further liabilities.
Thank you.
So, this report's delivered, and the claimant then sees that, according to Saboowala, he should only be paying 91, rather than the 2 million and then payment full, and then the further payment.
How Crowe has come up with any figure, since they're saying that the figures are unreliable.
Well, they're saying this is the figure we can come to, but there may be more liabilities.
Right.
But the claimant at this point is thinking, well, okay, there may be more, but I'm happy to pay this amount and just and then deal.
Yeah, that's what he accepts the advice.
Yes. Then the other side then say, well, we don't accept this.
Right.
Paul and Hassan should look at this. There is then, these new documents that you're handed up today are instructions to Paul and Hassan.
Yes, I put that in the back of the bundle.
I think it was 823, wasn't it?
2, didn't it? Yeah. You want me to go there, do you?
We don't need to go there.
What is it?
They're just instructions. One's an instruction to, but it's Paul and Hassan retainer letter,
right,
saying that it's acting on behalf of RAG to investigate or to look at the company as of 31st December 2015. And then there's another statement which is signed by both the claimant and the first 2 defendants, which say they'll cooperate with Paul and Hassan.
Right.
And what the claimant says is, in his first witness statement, is that Paul and Hassan were meant to look at everything within a 7 to 10-day window because Saboowala had done all the work and then produced their report, but they didn't. And what he says is he was asking for several months from this point after September for the where is the Paul and Hassan report, but it didn't appear until the 12th of January 2017. And in the meantime, as you'll see now, he's requesting for things to be moving, but they're not. So if one looks at 326.
I'm sorry, say the number again.
326.
296.
300.
396. Yeah,
326. 326.
326.
Yeah.
Sorry. Yeah, got it.
Okay, so this is Ilyas, so who's the claimant writing to the first defendants, well, both defendants actually, first and second. So saying, we're thankful for your initial cooperation.
So let me just understand who's writing to who.
So the claimant...
Rag Foods to...
It's Ilyas. Ilyas Gaffar Saboowala is the claimant in this case.
Yeah.
So he's the manager of the company, he's the purchaser.
Claimant, yes.
And he's writing to the first two defendants,
right.
and they're CCing various people there, including his lawyer, and including Sajid Gaffar, who's the signatory on the accounts, who's a director of Farmex as well.
Right.
And he says, we're thankful for your initial cooperation, being finance manager of the company, in providing all records and books of accounts for due diligence report. We regret to state that gradually your support and assistance for due diligence was withdrawn to the extent that you didn't provide annexures. So there's a reference to the annexures, while handing over SPA to auditors, which were already with you, and you kept promising Crowe Horwath auditors about sooner handing over of the same for completion of due diligence. You can see here that we talked about language. Well, you can see that Mr. Saboowala can write English, but it's not 100%.
Yeah, what's he trying to say?
What he's saying is that he's grateful for the cooperation so far, but he's concerned that actually their support has waned.
Right.
So he's sensing that something's going wrong. And he's saying what we haven't got, in this second paragraph, we haven't got the annexures. These are the annexures we spoke about earlier, which detail the premises and the vehicles and the intellectual property. And what he's doing is confirming the story that we're now presenting to this court, that actually they were with the defendants and they should have been given to Crowe Horwath, but they weren't. He then goes on to say, and that you are finance manager of RAG, and upon Crowe Horwath auditors requesting for a meeting in person to discuss and review the draft of due diligence which was carried out by you. Moreover, you didn't realise the need or necessity of keeping the purchaser informed of correspondence while responding intermittently to Crowe Horwath auditors and Galadari lawyers. It's agreed that you assisted to stock valuation for the year ending of 2015, but abstained from furnishing them records of GRVs to properly finance due diligence. So again, what he's complaining about here is he's saying, you've got the Crowe Horwath report, you've not really provided your comments on this, and we're requesting a meeting, you can see that from the first line, but we're not getting any cooperation from you. Then the next paragraph down, soon upon completion of DD report, based on the records and information furnished by you, especially in the capacity of sellers, authorised representatives, you and sellers were called by auditors to resolve some queries to conclude the due diligence, but none bothered to confirm the meeting. So again, he's complaining about them not turning up to a meeting. Next paragraph, your and sellers' such negligent behaviour and constant abstinence from responding to the requests or queries of purchaser, their auditors or lawyers with satisfactory responses, answers have unfortunately led to significant delay in sooner execution of the SPA. And by that, he probably means completion. And he's asking them at the end of this email for their kind cooperation and compliance in respect to the SPA, and then saying a failure of which will hold you liable. So that's that, 385, one looks at page 385.
385?
Yeah.
Yeah.
I mean, again, my lord, I don't want to bore you by taking through every single email, because there are lots of them. But they all go to the same point. They're all chasing for signatory of checks to run the company properly, or for some cooperation in relation to the due diligence and or completion. But I'm looking at the email at the foot of which starts at the foot of the page, the 12th of November one. Again, it's from Ilyas to the defendants, and copying in Dinil. Dinil Kumar is the manager of RAG, who is a representative of the first two defendants. So he's on their side of the fence, as it were. At page 386 is the email that I've just referred you to. So, dear Mr. Soman, Mr. Dinil, find the attachment. Due to non-signing of the cheques, we were forced to pay the outstanding amount by cash, as it was overdrawn, and it was for the purchase made in 2016 to Universal Flexible Packaging Industry. We request you to kindly cooperate for the smooth running of the operations. So the point here is that the claimant is saying, look, I'm having to pay cash to satisfy these bills. I need your cooperation. Now I'm going to have to ask you to pick up bundle 3 and look at page 962. Page 962.
962.
It's at tab 28. 962.
Yeah. All headed without prejudice.
It is, but I don't believe it actually is without prejudice, and both sides seem to put emails in like this. There's a reference to an email of 27th of October, and it says, please note this appears to be just another attempt on your part to delay the transfer of shares to me by both you and Mrs. Soman. As per our sale purchase agreement, blah, 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 has been completed, I'm ready to fulfill my part to pay you the balance. And you're under an obligation to transfer the shares in my name. For reasons better known to you, there appears to be an unlawful attempt by you to delay this transfer, as is evident from the fact that you appointed Paul and Hassan to carry out the audit. In light of the above, it's requested, please kindly transfer the shares with immediate effect. So,
I mean, that is an offer to pay 91,000 rather than items 4 and 5.
Yes, but what the claimant says is at this point in time, the Paul and Hassan report has not appeared, despite the fact that they were instructed months earlier. And as I said, the actual report doesn't turn up until the 12th of January. So one can sense and understand, perhaps, the frustration of the claimant at this point in time, because he's in this limbo situation. He's in this company, incurring liabilities. He ought to have the benefit, but nothing's happening. And I have to apologise for switching these bundles around, but we'll have to get back to bundle 1. And page 327.
327.
Yes.
Yeah.
So this is now, we're now moving ahead. So that was the last email was the 1st of November. Now we're a few weeks later, the 15th of November. Then, again, an email from Ilyas Saboowala, the claimant.
Well, that's just all the same thing.
All the same thing.
Yeah.
So I won't read it all out.
Right.
Page 333.
333?
Yes.
Yeah.
This again, a week later, or so, just over. But now there's an allegation, once he's at the second email on the page,
Yeah.
so the foot, we came to know that you were making changes, alterations in the books of accounts of 2015 in the system. And as you haven't provided us the audit report of 2015 prepared by Paul and Hassan auditors, we're suspicious about your intentions. So what he's saying here is not only have we not received the Paul and Hassan report, I'm now aware from being in the company that some changes are being made to the accounts. And as a finance manager, you've maintained books of accounts from last many years as your responsibility. And then it says, please provide satisfactory explanations for the given below queries in detail. And then there's a whole list of things here and questions.
Mm.
There's an email above on the same page.
Yeah.
Same sort of thing. So at 370, page 370, we're now into January 2017.
Yeah.
And the Paul and Hassan report has been provided now, and we'll look at that in a second. But one can see here, again, the issues with the checks coming back. All the checks were verified by Daniil Kumar, that is, and kept on the table in your office. Out of the total checks submitted, some are very urgent checks of sponsor fees and suppliers wasn't signed. After so many requests pending for signing from the 28th of November, which has already been presented several times, you'll see, and there's a whole list here.
Yeah.
And again, you see at 371, similar complaints referring to excuses for not signing. At page 372, you see a response from Dinil Kumar suggesting that he is complying, but clearly not to the satisfaction of Mr. Saboowala. Page 343, and sorry to take you back.
Sorry, 343?
4. Yeah. Again, requests for paying a bill.
Yeah.
358. Very similar table to what we saw before, but now the date is 1st of April 2017. And there's still a list of suppliers that haven't been paid, checks that are outstanding. One sees 359 as well. So the dates leading up to April, you see at 359. Page 359. So there's two emails on that page. So the email at the foot of the page refers, since the last 6 months, you haven't attended a single meeting, and repeatedly making excuses to avoid the meetings essential for clarification and resolution of the problems caused to us. And then if you look at the third paragraph of this page, I'm requesting you don't make any more excuses in order to avoid the meeting and stop creating hindrances in the affairs of business. Transparency, you're creating problems by not signing the checks and other essential documents required for the smooth running of the business. Accordingly, you've successfully made us helpless and continuously make attempts to beg in front of you for our own money after investing a huge amount in this company. So we've seen again reference to Mr. Saboowala putting money in, and this is exactly what he's saying here.
That's the legal authorities at the bottom.
Yes.
Who are the legal authorities? The police?
I don't know.
Difficult to think anybody else. Right?
Well, it could mean the courts. And again, he's English speaking, but his English isn't 100%. Right. I don't know. But either way, it doesn't. Whatever he meant doesn't seem to have assisted. At 5, and there's numerous emails. If one turns the page, again, I won't read these out. At 360, 361.
Where are you now?
I'm at 360.
360?
Yes.
Yeah.
So there's an email at the foot of the page requesting a personal meeting.
Right.
361. I mean, all these emails, they basically, in this line, chain, they go back from between February and April. They detail all the requests that are being made by Mr. Saboowala for cooperation on all these different fronts. 362, 363, again, all the same kind of thing. 364.
Yeah.
Now, I mentioned that the report of Paul and Hassan was produced. And one sees what the other side say is the Paul and Hassan report. It's at page 566 of bundle 2. Yes.
Yeah.
So there's 3 pages here, which, according to the first defendant's witness statements, is what Paul and Hassan provided. And you have 2 tables. One is as per seller and as per buyer, and then an explanation of the difference. And one of the big differences is the item, which is 3.863 million, recurring deposit in CBD.
So I'm not seeing it at the moment.
So I'm looking at page 566.
Yeah.
And there's an item against the fixed assets, which says recurring deposit in CBD. You see that? It's against fixed assets.
How far down?
It's about 5 items down. So you've got value of stock.
Oh yeah, I got you now. Yeah.
And that's by far the biggest item. It's 3.8 million. And what Mr. Saboowala says is this is a deposit for a loan, which, when repaid, the money would then go back to the defendants. And therefore, it's not money that he has to pay. It's simply money that was there on deposit in relation to a loan, which was a liability falling on the defendants. And it was in the CBD account. Now, I mentioned at the outset that there was an agreement that one account would be monies for the defendants, one account would be monies for the claimants. The CBD account was the defendant's account. And this 3.8 sits there. And what the defendant says, and said in his first witness statement, was this amount shouldn't be part of the consideration. It'll just go back to the defendants once it's been satisfied. And that's by far the biggest amount. And everything else, I mean, there are disagreements about all the figures, but then they're not as large as that figure. Now, importantly, if one looks at page 568, the very last item says received. And you can see there 4.25 million. And what we say is that the defendants claim that actually the claimant has only paid 3 million is disproved by the Paul and Hassan report itself, which was produced on the instruction. I'm
very sorry, I'm afraid you've lost me.
Okay, so I'm looking at page...
Can we just go back?
Yes.
You say these are the only 3 pages produced from the report?
There may well have been more, but these are the only 3 that are attached to the witness statement of the first defendant.
But I mean, you didn't receive a copy of the report?
Only 3 pages, I'm being told.
Just the 3 pages?
Yes.
Okay.
But
and then just going back to page 566.
So there were 3 pages, plus there were annexes that were referenced, and we received those as well. But they're not being produced by the...
Yeah, you didn't receive the report.
This is the report.
Oh, I see, okay.
Apparently.
All right.
This is the report. Yes.
Okay.
And this is the way that this is the way it's described.
This is the report with annexures as well. So there are annexures.
Oh, are these the annexes that follow in the document?
Those are my instructions.
Well, you both lost me now.
Okay,
what's
so
the first page of the report?
The first page of the report is 566.
Right. Well, let's look at the first page.
So that the item, again, I'll go back and I apologise if I was unclear.
Yeah,
the item
the recurring deposit in CPD.
Yes.
CPD stands for?
That's the Credit Commercial Bank.
Credit Commercial Bank. Okay.
There are two bank accounts of the company. One of them is a commercial bank account, and the other one is a Habib Bank. And it was agreed between the parties that the Habib Bank would be operated by the claimant,
right,
and the CBD account would be operated by the defendant.
Right. Now, this is a sum of money deposited in the defendant's account.
Yes.
Of 3.8 million.
Yes.
And you say,
we say,
I don't know where you're going from, but let's assume you're right, that is a loan from another company.
No, we say it's a deposit, essentially there to secure a loan from a bank. And once the loan is paid off, this amount then gets released back to the company.
I see. So it's a deposit to secure a loan of what?
Of money, property. Loan on property, a loan for property.
Right, so it's a deposit to secure a loan made for property.
Yes.
And once the loan is paid off, which was 3.8 million, presumably.
Yes.
I don't quite know why you deposit the money in order to get the same loan, but there it is.
I don't know.
That money would be returned to the defendant.
Yes.
Right.
And therefore it shouldn't properly be considered consideration. Right. The other figures you can see.
And then it says Well, if it points out the difference, then this was not considered by Farmex. What's that mean?
Farmex is a company that's owned by Mr. Saboowala's brother.
Right.
And Mr. Saboowala, when he came to Dubai, didn't have a bank account. And his brother had been operating in Dubai for a while. And he has been assisting him with the transaction. Now, we've come across his brothers already. Sajid is the person who is the claimant's nominee on the bank account, the signatory to the bank account. But also, Farmex assisted in instructing Thoruvil, although it was always recognised that it's actually the claimant who was doing it. But that's why Paul and Hassan refer to Farmex. We say they actually mean that they're referring to Mr. Saboowala. But this is the company that was assisting him. But that's what
I think I understand. Well, I'm not sure I do understand, but maybe I don't need to. And then we've gone to page 368.
568.
568.
So it's just a few pages along.
And then we have
there's
receivables of 42 million, is it? Yes.
568, I'm looking at.
Yes.
You can see there's three items. There's a net figure, then there's an item which says received.
When I see that, what on earth it means, I don't know.
Well, what the received mean, what Paul and Hassan are doing is working out how much the claimant owes the defendants in terms of the purchase price.
Okay.
And so the received amount they're taking in the received amount, they're taking account of the amount that's already being paid. And the amount that they've got that's already being paid is 4.25.
Right. Well, you may be right. So this document suggests that 4.25 million has been received by the sellers.
That's what I'm being told, and that leaves a net amount of 8.263. Net of the.
But that can't be right because the purchase price was 10.5 million.
One at a time. Sorry, Ms. Ahmed.
Sorry, that can't be right because the purchase price was 10.5 million. So that can't be right.
Because it takes in the Paul and Hassan report takes into account various liabilities, which is why it fluctuates in this way.
Well, this is a defendant's document, is it? Yes.
Yes.
Yeah. So you say it records payment of 4.25 million to the defendant.
Yes.
And that the net figure at the top is supposed to reflect what the sum ought to be paid.
Yes, the first column is the column of Paul and Hassan. So what Paul and Hassan are saying is the claimant should be paying the defendants 12.6 million.
Right.
They've already paid 4.25 million, so they should now pay 8.382 million.
Yeah.
But the next column shows the difference. Shows what Mr. Saboowala is saying, or Thoruvil, more to the point, is that the net amount is 4.368 million, but he's paid 4.25, which is why he should only be paying 118, which is the 118,000.
Well,
the reason why it's different is because this is now a different period in time. When the Thoruvil produced their report, it was the 31st of December. But now this report is being produced in January 2017. It doesn't say exactly when it's calculated.
Sartman will explain this document in due
Yeah.
course. You say it's of no assistance. I'm not quite sure what you are saying.
Well, there's two points. We're saying, number one, you can see that Paul and Hassan also accept that 4.25 million in terms of the consideration has been paid, because both sides of the column at page 5.
And that reflects what? Items 1, 2, 3,
and these additional payments that were requested. Because what Mr. Saboowala says in his first statement is at some point in June, I believe, of 2016.
Anyway, I'm not sure these accountants can just tell me what was paid under the terms of the contract.
Well, they may not be able to say what was paid. But
they just say these sums are being paid.
We say they're being paid,
right.
and the others, we say that the party instructing Paul and Hassan is one of the defendants. So they must have had that on an instruction.
But what's the 1.25 represents what?
It represents two checks that were made.
Yeah, but in respect of what?
You mean why those figures?
Yeah.
Mr. Saboowala said the defendants were saying, look, we want money up front now, we need some money. And so they came to an agreement that he'd make 2 payments.
So it's not by reference to item 4.
Just towards the purchase price, I'm being told. Just towards the purchase price. Not
well,
by reference.
I've no doubt there's some evidence about that. I have to say it's beyond me at the moment. Thank you. Right.
But
so I mean, you're
the other point here is that.
But what's the significance you place on the 3.863?
Well, simply when one strips away that, if Mr. Saboowala is correct about the 3.8 million, actually the difference between the 2 reports is large, but not necessarily surmountable. In other words, there is a basis here for some kind of discussion and negotiation.
Well, it's still 5 million or so.
Yes, but each individual item is 100,000 here or there.
Okay.
But the point here is once this has been produced and you've got the Crowe-Horwath report, the parties ordinarily should sit down, explain what the differences in relation to each of the reports have been produced, and try and reach some kind of agreement. That hasn't happened. And what the claimant has said, and what we've seen in the correspondence, is he was attempting all the time to do this, but not getting any joy. And at the same time, he was trying to run the company, but also not getting cooperation in relation to that.
Well, it's an unusual man who is prepared to continue buying a company whose accounts are bogus, where the existing personnel are unwilling to assist him in running the company and won't sign any checks, won't have a meeting with him. It's difficult to understand what on earth he's doing continuing with this purchase.
But the answer to that is that he sees value in the company. He sees value in the...
Well, you can see bogus value in the company, yes.
But
as I understand it, he accepts that all these accounts are entirely bogus.
But a company has goodwill, has potential...
yeah, but they're running a bogus account, full of sham transactions.
Which were identified. I mean, the other point...
Identified internally, but not to the outside world. Okay, right. There we are. Now, where do we go next?
Then 367. We've already looked at. So then that takes us up to April.
So while I'm thinking about it, my notes has got rather left behind. I can always ask for a transcript, but I would be grateful for a list of the page numbers you've referred to in the order in which you referred to them.
Yes.
It would help me in due course.
We'll endeavour to do our best. Right. So now we're in April.
Yes.
In March, this is where matters come to a head. In May, this is where matters come to a head, because as I mentioned, by the 9th of May, there is an issue that arises, and the claimant is effectively removed from the company. And what he's concerned with is he's concerned with Dinil Kumar, this individual I mentioned before, who's a manager. He refers to being pushed and being insulted, but he also refers in his statements to this lack of cooperation. And so he considers that he's being thwarted. He suspends Dinil. The defendants don't like the fact that he's taking these steps. They then, according to the claimant, of course there's going to be a dispute about exactly what was said and when. The claimant then says that the defendants then made it clear that they were the owners and that the claimant was not the owner, and that was the end of it. And they then shut him out of the company, and I believe the police were called. And it's in that context that the claimant then thinks, I'm going to just cash these checks. And if one looks at bundle 3, and looks at page 958,
Yeah.
one sees there's an email from the 22nd of June where, if you look at...
page?
It's 961. Oh, sorry. 958 is an email from the 22nd of June.
Yeah.
Which the claimant now writes, and he's using his Gmail account because he's no longer at RAD, he's no longer at the company because he's been excluded. And there's a whole list again of complaints. And you can see at the end, what he's saying is, I still insist that you comply with the terms.
So where are you reading?
I'm reading right at the foot of the page, the second to last line.
I being purchaser manager.
Yes, and the very last two lines. I still insist that you comply with the terms of the agreement, and the shares should be transferred to me at the earliest.
Yeah.
So he's still calling for completion at this point in time, even though he's been removed from the company.
Well, completion on the basis of 91,000, presumably.
Yes, but or if they sat down and discussed what was wrong with the Crowworth report, and they showed why the report on Assam was correct, then he would settle for that amount. But what he wasn't prepared to accept was them simply just not doing anything at this point in time. And that's where we leave it. I mean, he starts various proceedings and he makes a police complaint because the check's bounced. And we've already discussed that, and we accept that he should have gone to the DIFC court. Having said that, the checks were unlawful to the extent that they weren't backed by cash. And that's where we are. Now, what the defendants say is that the agreement has ended because the claimant has repudiated the agreement and they have accepted the repudiation. And they make a whole series of allegations in their defense, but they actually boil down to really 3 points. One of them is that he's repudiated the agreement by seeking to complete on the basis of the Horwath report. They say he's repudiated the agreement because he retained the security checks and then he sought to cash
Sorry,
them.
the first one was what?
Was he sought to complete on the basis of the Horwath report.
The which
So
report?
the Horwath.
Failing to complete, yeah.
Number two, that he...
They were saying that there was a failure to complete in accordance with the Horwath report.
No,
they weren't saying that.
No, they're saying the repudiation is that the claimant was insisting on completing on the basis of the Horwath report.
I understand that, yeah.
In fact, they put it in one place, they put it slightly differently. They say because there was no agreement on completion, on the completion amount, the agreement effectively ends.
Right. Well, that's a different point.
It's a different. They blur these 2 points, but they come under the same heading. The second point they say is that it was a repudiatory breach for the claimant to cash or to seek to cash the security checks.
Yeah.
First to retain them in the first place, and then to cash them. And then they say, thirdly, that it was a repudiatory breach for him to have made complaints to the police or start proceedings in the wrong jurisdiction.
Yeah.
And what we say is that none of those things can be a repudiatory breach in the circumstance of this case. And it's worth reminding ourselves what one needs to have a repudiatory breach under DFC contract law. So if one picks up the bundle of authorities prepared by my learned friends, at tab 1 is the contract law, DFC law number 6 of 2004.
Yeah.
And I'm looking at Article 86, which is at page 19 of the law.
Yeah.
Right to terminate. A party may terminate the contract where the failure of the other party to perform an obligation under the contract amounts to a fundamental non-performance. In determining whether a failure to perform an obligation amounts to a fundamental non-performance, regard shall be had, in particular, to whether the non-performance substantially deprives the aggrieved party of what it was entitled to expect under the contract. Strict compliance with the obligations which has not been performed is of essence under the contract. The non-performance is intentional or reckless, and the non-performance gives the aggrieved party reason to believe that it cannot rely on the other party's future performance. And our basic point here, and I'm going to elaborate on it, is that none of the things complained of do those or satisfy those elements. If one looks at paragraph 26 of our skeleton argument, go through in detail and respond to the defendant's points. So at paragraph 26.1, we deal with the issue of whether there has to be
You say 26?
Yes, and 26 is my skeleton argument.
Yeah.
Okay, 26. So I'm dealing with each of the points made in the defence. So 26.1, the defendants maintain that the amount of consideration during the SPA is a matter of future agreement. And we say, well, that's of course not the case. The consideration has to be valued, and it's an objective matter. So that's point 1. 26.2, that the transaction is required to be unravelled in the event of a failure of due diligence process for whatever reason. And this is the point we dealt with originally. We say, well, that can't be right. It can't. The claimant must be able to say, despite any gaps in the due diligence, I still want to buy this company. Let's sort out what the value is. Then, 26.3, the defendants alleged the due diligence process failed because the claimant sought to allow the Horwath report, which is materially inaccurate. And they go further. They actually say, on account of collusion between the claimant and Horwath. So they actually make an allegation that somehow the claimant was in collusion with Horwath. And we say that allegation is made flippantly and without any basis whatsoever. And the real position is, Crown Horwath did their job. They came up with a figure that the defendants didn't like. The defendants went and got their own analysis, and they should have sat down and seen if a gap could be bridged. If not, the court would have to intervene. But they didn't do that. And it's their absence and lack of cooperation, which we've seen from the documents, which has led to this breakdown and the situation that we're in now. 26.4, the defendants further maintain, in essence, that the claim was a repudiatory breach. Now I've set down the points that I just made in relation to the points that I summarised a moment ago. But the point about the claimant cashing of the cheques is, he says that he cashed these cheques because he was excluded from the company and he wanted to recover liabilities incurred as a result of the defendant's actions.
I mean, that's not why the cheques have been furnished, in order to secure his position within the company, or to provide security for any liability he might incur. They were provided for express reasons under the contract.
That is undeniable. That's what the contract says.
Right.
And he may have been mistaken in his approach to try and cash those cheques. But what we say is, no matter what his mistake is, it was clear from the correspondence that he wasn't, by cashing them, he wasn't attempting to unravel the agreement or not to pay them for the amounts that they were due, when I say them, I mean the defendants, under the contract. On the contrary, the whole time, as we saw, the 22nd of June email, even after he attempted to cash his cheques, he was saying, I want to complete. And it may be that he made an error in trying to cash these cheques, but he never was seeking to rely on clause 2.4, as the defendants admit, and unravel the transaction. And he was never trying to unravel the transaction, because all the time he was making it clear that he wanted to complete. And in fact, as he was part of the proceedings that he brought in Dubai, as I mentioned, one of them was for an appointment of a receiver, which would only make sense if he believed that the agreement was still on foot and that he was entitled to the transfer. That's what he's always wanted. And what we say is it's clear from the documents that the claimants, the defendants, understood that that's what he always wanted. And indeed, they sought to resist the payment of the cheques. And what they say is that they paid money into court because they were compelled under duress to do so. They weren't doing it because they were unravelling the transaction because they believed that's what the claimant wanted. That's not the position. And an additional factor, which we say the court has to take into account, is that the cheques were not, as far as I understand it, even by the defendant's admission, not backed by cash. And for that reason, when they were tendered, they were unlawful.
Well, I suspect he hoped for that.
Well, that's an inference that you're entitled to. You mentioned that that's one that you're minded to make. Our point about that is there's no actual direct evidence, and the court would have to make that inference. And with respect, and say the court should be hesitant in relation to that, in relation to someone who's not from this jurisdiction, who is actually trying to, who's saying in emails that we've looked at, he was trying to. He said,
sorry, could you say the last one again? That he's not within the jurisdiction.
He's not from this jurisdiction. He wouldn't necessarily.
But he lives here, doesn't he?
Sorry?
I thought he did live here.
He lives here now, but he came from abroad.
Oh yeah.
And the purchase of the company was part of his move here.
So did I.
I'll say that. The point is in relation to that is again that he was saying in emails that
he really saying he didn't realise that if the cheques were dishonoured, he could, in a sense, rely upon the fact that the defendant had committed a criminal offence. You didn't know that?
I don't know, and I can't possibly say what he knew.
But what I'm invited to assume that he knew that perfectly well.
But my lord, what we can say is, and we've seen evidence for this, is that he was concerned that he had personally invested money in this company, and that money would go to waste. And we've seen emails to that effect.
Yeah.
And therefore, we would submit that actually the court has just as much ground to infer that he was hoping to recover some money that he'd put into the company pending in order to compel completion through the Dubai court. And although that was misjudged because the Dubai court was not the correct, what he really wanted to do was compel completion and recover some of his money.
Well, he could have come to this court. And he did many months later.
And he should have done that, given the exclusive jurisdiction clause. And he didn't.
He'd been threatening legal proceedings, hadn't he?
Yes, he had, but it's not clear.
But he never instituted them.
But we would suggest that because a party is willing to offer a hand of peace and be conciliatory and try and resolve matters, he shouldn't be punished for not going to court swiftly without giving a proper opportunity for the parties to come together. Because from his point of view,
that's a bit rich if he actually goes to the Dubai court.
Well, at that point, as I say, he made a mistake. But we say it would be very harsh to penalise him for essentially going to the wrong jurisdiction, but having been put to great hardship in the first instance. And we say that doesn't amount. It may be bad, it may be wrong, it may even be compensatable in damages, who knows. But what it isn't is a repudiatory breach, especially when all the time he's saying, I actually want to complete.
Thank you.
And in relation to, then the final point is in relation to the acceptance of this repudiatory breach. What the defendants say is that their first acceptance is on the 9th of May 2017, where they evict him from the company, evict the claimant. And we say that's simply kicking him out of, breaching the agreement itself. And they then refer to
it's a legal notice there,
which is on the 9th of July. Yeah. Which, when we talk about lateness, I mean, he cashed these checks in May. I think it was the 22nd or thereabouts of May.
Right.
But they only served this document it should be mentioned, the Dubai courts in July.
What you're saying?
But isn't that document a Dubai court document?
No. No, it's a
notice. The notice is, if I'm not mistaken, it's at 682 of bundle 3.
Sorry, bundle 3?
Yeah.
Page 602?
682.
82, thank you. No, that's not bundle 3.
But it starts on 679.
Yeah, they do.
Oh, I see. Right. So I was in error. I mean, I assume it was just a letter. Is that correct? The reason I thought it was a legal notice is because it's a legal translation, which is the same form as some of the court documents. But it looks like it's a translation of a letter. That was initially sent by our Saudi company advocate. So 679 is the start of this.
Yeah.
And then the important bit is on 682.
Yeah.
And if one looks at the paragraph, the first paragraph of the page, consequently, the warning parties were forced to offer the value of these two checks. And
Yeah, sorry, were you reading 682?
First bullet point.
Oh, I see, yeah.
So it's explaining why the warning parties. I mean, I assume that this is a letter before action of a sort. I'm not quite clear what it is, but no doubt we'll hear. But what it's saying is they were forced to pay the money back. They didn't want to pay the $3 million into court. Then they go on to say, whereas the warned party by such acts has severally breached the articles of the SPA, and this shall be deemed as termination of the contract on his part. So they're not accepting the repudiation. What they're saying is, because he's cashed the checks, he's terminated the agreement.
Okay.
Which is different to the way I believe it's put. And for the reasons we've said, it should have been clear, and it's been made clear by the claimant all the time, that was never his intention. And again, misjudged perhaps, but a repudiatory breach, certainly not, and an intention by him to terminate, well, certainly not. Now the checks themselves are, I think, 671.
Yeah.
And 672 is a reference to. No.
Sorry, what am I looking at?
No, don't worry. I was trying to find the checks that were made.
Well, I don't learn very much from that.
No, you don't know that. It's a wrong reference. The point of I'm going to need to find the reference. But the point I believe is that the payments into court were not made personally by the first and second defendants, but the payments into court was made by RAG. And what the claimant says is they were using RAG's money to pay money into court.
Right.
And this is money that the claimant says is the money he put into the company as part of his investment into the company.
Right.
And so what the claimant's saying is actually they haven't even paid money into court because they were essentially paying his own money back into court. The only relevance of this is that in terms of the way the court looks at this, and that's the question, is this a signal of an intention to terminate by the claimant? We say no. And the second issue is whether this is repudiatory, or enough to be repudiatory. We say no. And whether that has been accepted, again, we say no. And so...
Well, it's been accepted since, hasn't it?
Yes, since.
There's been no affirmation there, is there?
Well,
I mean, assuming there's a repudiatory breach.
Well,
I understand your point on that.
Yes.
But assume there was.
Yes.
There's been no affirmation, has there?
Well, the affirmation would be if, in fact, they didn't accept within a reasonable time that these checks, the tendering of these checks were repudiatory, and they didn't accept that, and yet the claimant continued to push for completion and took steps in that direction.
That doesn't constitute an affirmation by the defendant, i.e., an unambiguous decision to continue with the contract.
Yes. No.
No.
It doesn't. It doesn't. So, I mean, those are the points.
That's very helpful.
That we make about repudiation. And so, essentially, although this case is messy, we accept, and complicated, what we have, in many ways, can be boiled down to this. There's an agreement by my client to purchase this company. He has due diligence carried out, not entirely satisfactory, but he's willing to accept it. The other side don't say no at that point. They go and get their own auditors, Paul and Hassan. There should have been then an attempt to come together. There wasn't. This court should decide what the consideration is, whether it has or hasn't been paid, or what the amount should be. In the meantime, it's clear from the contract, however bizarre this is, that from execution and payment, particularly of the first three tranches, which everyone accepts has been paid, the claimant was meant to have ownership of assets as set out in various annexures, and also singly manage the company himself, and also have his nominee appointed to the account of the company. And because, and this is again is clear from the agreement, there's a cut-off date of the 31st of December 2015, and after that date, everything would be to his benefit, all liabilities would be for him, whereas the defendants were meant to settle all liabilities prior to that date. And what we say is that...
But even the benefit of all the dummy transactions.
Well, what the defendants say is that actually the dummy transactions come out in the wash. They were dummy, or they don't accept they're dummy, but what they say is they've been identified, sorted out, they don't actually affect anything. And therefore, the company can be cleansed properly. And the claimant, we say, is entitled to make that decision commercially and say, I'm not happy with the way the company's been operated, I can operate it better and make this a very good company going forward. He hasn't repudiated that agreement. And so all we're asking for today is some form of protection over the company while the court deals with the issue of the purchase price. And that really is what it boils down to. We've given the court a range of options, and it's correct that the share transfer to our client would be a very high burden on us to try and show that. But the other points are not, and certainly a receiver is possible. And unless you have any further questions, I'll sit down.
Well, just help me on damages for a moment.
Yes.
I mean, on your case, I know you haven't accepted it, but on the face of it, the defendants are in repudiatory breach of this agreement. Or at least in breach.
Yeah.
And you say damages are not an adequate remedy. Why not?
Because we're dealing here, number one, it's equivalent to a land transaction. So we want to buy this particular company to do particular things with this company. One of the reasons for buying it, and I've mentioned the Farmex company and Mr. Saboowala's brother, he owns a company in the same industry. And therefore, this company is of value to him, in the sense that they can work together with his brother in the same industry. And that is not something that is easily quantifiable. Furthermore, that's point number one. Point number two is it's very difficult for a court to quantify damages if, for example, the court doesn't make an order and the defendants are allowed to continue running this company. The court would then have to assess the difference between them running the company and our client running the company. And we say that would be a torturous and very difficult assessment to make. And the fairest...
Well, not in the future they wouldn't, would they? The consideration... oh, I see you say, no, well, you would be entitled to recover what monies you would have made if you'd been able to take the company.
Because we would have been, if the court finds in our favour, the court will say, you should have been running this company. You should have the benefit from it.
Yeah, okay.
But in fact, we have the defendants in there who the claimant says are running this company in all sorts of ways which aren't right.
Okay.
And those are, we say, the two main points.
Thank you. Now, just tell me now, you have your alternative claim for the appointment of a liquidator.
Yes.
I need some help on jurisdiction.
Yes, so there's a case which it's the only case which we handed up, which is Derby versus Weldon.
Which one?
It's number 3 and 4, and it's a Court of Appeal case.
Are they in the bundle?
It's not, and we can do a fresh copy. We sent it to the court, but we're just finding it.
Well, first of all, just tell me what's the proposition you're...
The proposition is that you have if you've got jurisdiction over the parties, then you have jurisdiction over the parties' assets.
Thank you. Yes, that I follow.
And
can I appoint a liquidator of a foreign company?
Yes.
Right.
You're a receiver you're appointing.
I'm so sorry, yes, a receiver.
Yes. If you look at paragraph 80, page 84,
Yeah, do that. Yeah.
and you see the foot of the page, extraterritoriality.
Yes.
Sir Nicholas Brown Wilkinson posed the question, this is the lower court, whether it was right to the court to appoint a receiver of assets outside the jurisdiction belonging to a country which had no residence in this country. And he answered by saying, and you can read that paragraph.
Let me just read that.
Yes. There's page 85, is just kind of paragraph in quotes.
Yeah, okay.
Thank you, I read that.
And then when one continues, one sees what Lord Justice Donaldson says. So he says, I think that there may have been some confusion between the objects and effects, because the Convention in no way affects the powers of the courts as stated, which probably sees the substance of the dispute. And if you just read that until page 86, just the first two paragraphs on that page.
Yeah, I read that, thank you.
So we say so the lower court recognises that you can actually make an order appointing a receiver over assets outside the jurisdiction of the company registered outside of the jurisdiction. The Court of Appeal says one doesn't even need to take account of the laws of that particular country. We say in terms of Dubai and the DISC court, given the arrangement between the two, the court does have that jurisdiction. In this case, it would be right to exercise it.
The Dubai courts would recognise it or might recognise it?
Well, if we would say they ought to, given the arrangements between it, but might is enough.
Right. Thank you. Thank you very much. Right. Can I just clear the decks a moment?
My Lord, before we do stop, may I seek a small indulgence? Is it possible to take an early lunch break so
Yeah,
that
right.
then I don't have to stop and start?
We'll start at 1 o'clock.
Very cool.
Okay.
All rise.
Can we just go into that room? There's someone outside of it. Set out. I just want to get my training. Actually, I'll work here. How many pages?